Good afternoon. I'm Commander Jentzsch from the Bundeswehr Center for Military History and Social Sciences at Potsdam. I have the honor to host the last panel of this year's ITMG, Military Justice and the Radicalization of Warfare in the Japanese Armed Forces during the Asia-Pacific War. It's probably one of the most cruel panels because it's between lunch and the end of the conference. This panel focuses on an area of today's interest too, East Asia and the great power struggle. But today's afternoon, we will focus on the first half of the 20th century. Yesterday, Professor Sönke Neitzel mentioned the lack of knowledge in Germany about this region, especially concerning military culture and the radicalization of warfare in World War II. This will partially be solved by this panel by focusing on Japanese judge advocates and legal advisors. It tries to help to explain why military violence radicalized at the end of the war through the eyes of acting officers, legal advisors, and judge advocates. And it shows how the enforcement and discipline was executed by the Japanese armed forces. Most of us in public culture may get in contact by this issue by the popular movies The Bridge on the River Kwai or Letters from Iwo Jima, displaying Japanese atrocities in the Pacific theater during World War II. But today we have three researchers presenting their findings on the above-mentioned topic and painting a scientific picture on this serious topic. We will start today with Dr. Tino Schölz. His presentation is about discipline and insubordination in the Imperial Japanese Army during the Asia-Pacific War. Dr. Tino Schölz is a researcher at the Seminar of East Asia Studies at the Freie Universität Berlin, and he works recently on the project Law Without Mercy, Japanese Court-Martial and Military Courts during the Asia-Pacific War, 1937 till 1945. He will analyze the structures and institutions of the Japanese military justice system as well as its punishment practice in the case of deviant behavior and crimes committed by Japanese soldiers. Now, the floor is yours.
Yeah, good afternoon, ladies and gentlemen. Japanese forces fought the Asia-Pacific War brutally and in defiance of international norms of warfare. This is remarkable when one considers that in the imperial wars against China, Russia, and Germany at the turn of the century, Japanese troops were seen as role models, which highly respected the emergent international law of war. The question of how to explain this radicalization and totalization in the 1930s and 40s has preoccupied historians ever since. Accordingly, there are a multitude of explanatory approaches that emphasize, for example, the importance of disillusionment with the international peace order after World War I, the prevailing brutal methods within the military, the role of racism, or the experience of total warfare in Manchuria after 1931 and in China after 1937. We are considering this problem from the perspective of military justice in the Japanese armed forces in our ERC-funded project Law Without Mercy ? Which aims to analyze the conduct of Japanese courts-martial, military courts, and of members of the military justice system during the Asia-Pacific War. According to our hypothesis, the military justice system's wartime practice itself was a decisive factor for the enforcement or disregard of national and international norms of warfare. It defined the boundaries between permitted and non-permitted violence for its own soldiers, and therefore parameters of military conduct. But at the same time, as an instrument of military power and strategy, it was an important actor of mass violence in the occupied territories and against captured enemies. Our three papers will discuss the problem from diverse perspectives. Different from the program, as Mr. Jentzsch already told you, first I will give you an overview of the structures and practice of the Japanese Army's courts-martial, and therefore the state of discipline and insubordination in the Imperial Army during the war. Then, my esteemed colleagues will give two papers on case studies. Matthias Zachmann will present on standardizing military violence, the role of judge advocates in the Imperial Japanese Army during the Second World War. This paper gives a micro-study of military justice in the case of Nanjing at the turn 1937 to 1938. It seeks to illustrate how judge advocates shaped soldierly violence, and vice versa, how the daily experience of violence shaped their legal practice. And finally, Kelly Maddox will give a paper on the limits of military necessity, unlawful trials, and summary executions in the Andaman and Nicobar Islands during the Japanese occupation 1942 to 45. This contribution discusses not only military justice against civilians in an occupied territory in the last phase of the war, but also its legal evaluation in Allied war crimes tribunals after 1945, and therefore highlights their role for the adaptation and development of the international law of war as well. In my paper, I would like to discuss the Imperial Japanese Army's military justice system and its handling of deviant behavior and crimes within their rank and files. By deviant behavior, I mean violations of legal norms committed by individuals and small groups, but not systematic war crimes like the infamous massacres or the scorched earth policy in northern China. The questions I would like to address are as follows: how the military justice system functioned, how deviant Japanese soldiers were and how they were punished, and finally, which links existed between deviant behavior, military justice, and the totalization of Japanese warfare in the 30s and 40s. Therefore, my presentation is divided into three parts. In the first part, I will analyze the legal and institutional framework of the Army's military justice system, as well as the widespread practice of informal punishment. In the second part, I will present some trends of crime and formal punishment during the war. And in the final third part, I will briefly discuss causes and countermeasures the Army took to tackle the increase in crime within their rank and files. I must admit, however, that my perspective is rather biased, as I must rely heavily on official sources, laws and ordinances, court-martial verdicts, reports on the state of discipline, which contain a fair amount of case studies, and statistical material produced by the Army bureaucracy. Let's start with a brief overview of the legal and institutional framework. Since the Meiji period, the prosecution of crimes committed by Japanese soldiers had been separate from the civilian administration of justice and had its own laws, institutions, and procedures. In contrast to earlier imperial wars, in which respect for international norms of warfare had been one of the central tasks of military justice, from 1937 onwards, it was explicitly mandated to maintain discipline within the forces on the one hand, and to protect the interests and honor of the imperial military on the other. In doing so, military necessities were to be considered. In practice, the ambiguity of these tasks opened considerable room for interpretation.
Herr Schölze, Ihr Ton ist ausgegangen. Herr Schölz, Verzeihung.
Ja. War der lange weg?
Nur kurz.
Nur kurz. Okay. So, well, in addition, the military justice system was bound for the in its actions by more than 100 laws and ordinances issued specifically for the Army, including the Army Penal Code, the Army Disciplinary Punishment Ordinance, and the Army Courts Martial Law, which standardized substantive and formal criminal law. The institutional framework included, firstly, a military gendarmerie, the notorious Kempe, which served among numerous other tasks as criminal police and investigated cases. At the end of the war, the Kempe numbered about 30,000 men, a figure that was obviously insufficient to fulfill their duties in the different combat zones and at home. Secondly, a separate military justice administration within the Army Ministry and unit headquarters, which consisted of legal affairs officers and clerks. They conducted preliminary examinations, filed indictments, prepared court-martial proceedings, and produced countless reports on the state of crime. Thirdly, courts-martial at different levels, including a Supreme Court-martial in Tokyo, punished almost all defendants brought to trial. Their composition differed, but in wartime, a court-martial in the field usually consisted of 2 field officers or NCOs and 1 legal affairs officer serving as judges, and another legal affairs officer serving as prosecutor. During wartime, legal safeguards for the accused, like the right to name a defense counsel, the publicity of the court hearing, or the right to appeal to the Supreme Court-Martial were abolished, leaving the defendant at the mercy of the court. Fourthly, the military justice system consisted in 1937 also of 19 military prisons, which served as places for the execution of sentences. In contrast to current international trends, where military justice officers are increasingly able to act independently, the criminal procedure fifthly centered on the commander. He was in every respect the master of the proceedings. He appointed judges and prosecutors, he could conduct investigations on his own, or could instruct the gendarmerie to do so. He had the right to stop any of these investigations, decided on public indictments, could override sentences, and had to order their execution. Whether the commander exercised these powers personally, or whether he merely signed what was put before him by subordinates, I cannot yet say. Probably it differed from individual to individual. But at least formally, everything was done under his authority. Besides this formal framework, there existed, like in most armies, a culture of informal punishments by superiors and comrades. Given its nature, this is a topic difficult to research. They took place inside the barracks as well as during training or in the field, and very often at night. Informal punishments ranged from insults and physical violence through punitive, dangerous, and humiliating tasks to encouragement to commit suicide. Typical examples are public abuse and humiliation, forcing recruits to perform degrading actions or excessive work, slapping, kicking, and other physical assaults, or forcing soldiers to give presents or to pay for another person's pleasure. Some sources suggest that soldiers were not only informally punished because it was common to do so, because it was regarded as a way to make soldiers tougher, or because military necessity or circumstances demanded it, but also as a means to circumvent formal punishments. Therefore, actively using or at least allowing informal punishments was probably quite often an attempt to avoid negative consequences for superiors that could result from serious crimes or a high crime rate. Negative consequences for themselves could include not only disadvantages in promotions, but also outright formal or informal punishments for neglect of duties. These ranged again from disciplinary punishments such as detention to sentences by courts-martial such as penal servitude to forced suicide or retirement to take responsibility. This also reveals a structural deficit of a commander-centered military justice system in which the interests and motivations of superiors can play a far more significant role than in an independently acting system. After the institutional and legal framework, in the second part, I would like to draw your attention to the actual developments of crime and the practice of punishment as reflected in statistical data. In doing so, I would like to highlight the actual boundaries between permissible and non-permissible violence that were drawn by the military justice system during the war. Between July 1937 and November 1944, a total of 26,290 people were found guilty by an army court-martial. Almost everybody who was publicly indicted was found guilty. Since about 1/3 of the suspects were not prosecuted by decision of the commander, I assume that the total number of suspects was about 40,000 people. Regarding sentenced persons, there was a considerable increase in total numbers, as you can see here in the slide, over the course of the war. In 1931, for example, 504 people were convicted, in 1938, 2,197, and in 1944, 5,586. The picture changes if we keep in mind the constant enlargement of the army and therefore calculate the ratio. Then we can see rather a wave with ups and downs than a sharp increase over the course of the war. Convicted criminals never exceeded the share of 0.25% of the total strength. Compared to the months before the outbreak of the China incident, this is indeed an increase, but it is still far less than in 1936 and the decades before. The next graph is probably difficult to read, but it is quite interesting. It shows who was convicted by a court-martial between July 1937 and December 1941. At the beginning of the war, most crimes were committed by older soldiers of the First Reserve in orange, while soldiers on active duty in blue on the bottom accounted for only 10% of all convictions. This is significant as it proves that at the beginning of the war, discipline among the younger active soldiers was significantly higher than among the older recruits who had been called back to arms and who were obviously less willing to submit to military needs, the authority of their superiors, or the rules of warfare. This reverses by 41, where almost half of all convictions can be ascribed to active soldiers. The change can be attributed above all to the declining proportion of reservists in the total strength of the army. And we can also see a considerable increase in the share of civil military employees in light blue. I omit the decimal places from 9 up to more than 23%. The share of this personnel, who were mostly recruited for auxiliary work and often had no military training and therefore only few ties to the military, also increased over the years. But what were Japanese soldiers found guilty of? In the first 1.5 years of the Second Sino-Japanese War, convictions for property-related crimes or crimes against civilians, such as looting with almost 12%, theft with 8%, and rape with 9%, made up a significant proportion. The share of offenses within the military, such as violence against superiors or desertion, were far less, at 5% each, while the biggest problem in this sector was apparently gambling. This picture changes after the outbreak of the Pacific War, and we are now talking about completely different absolute figures. The most significant crimes dealt with by courts-martial were now theft with 16% and desertion with 12%, which have doubled their share, while the share of crimes against civilians, as looting and rape, were down to 2.89% and 2.14%. If we aggregate property-related crimes, theft, embezzlement, and looting, we see that about 27% of all convictions can now be attributed to this group. Already contemporary sources link this increase primarily to the poor supply situation of the troops. Let's turn next to the question of severity of punishments of Japanese soldiers. Although I do not have conclusive statistical data here, preliminary exploitations give us some interesting hints. Firstly, a prioritization can be observed in the question of whether a case was dismissed or an indictment filed. As mentioned earlier, about 30% of all cases were dismissed. Apart from formal reasons, like proven innocence or insanity, this was apparently the most important place where commanders made use of their discretionary powers and where considerations such as the protection of military interests or the honor of the forces were taken into account. Other factors such as combat situations or the need to have soldiers during battle are likely to have mattered here as well. Accordingly, the likelihood of being charged with a crime within the military or with rape seems to have been significantly higher than in the case of killing a male civilian or for looting. Secondly, the probability of being punished with a maximum penalty was rather low. For instance, between December 41 and August 45, a total of 795 persons were found guilty of crimes against locals. This is mainly looting, rape with fatal consequences. Of those persons, nobody was sentenced to death, although this was the maximum penalty for rape with fatal consequences. And by far the majority was sentenced to penal servitude between 1 and 3 years, 57% most often for looting, or between 3 and 5 years, 26% most often for rape. Therefore, the actual punishment of Japanese soldiers was, compared to the possible range of punishments, rather mild, in contrast to the treatment of civilians in the occupied territories or prisoners of war. In the final part, I would like to draw your attention to the complex relation of crime, military justice, and total war. I would argue that an increase in crimes, especially against civilians, and the disregard for national and international norms of warfare are factors as well as indicators for a totalization of warfare. Let me briefly address 2 points here. My first point, the increase in crimes itself was linked by the bureaucracy to the conditions of total warfare. The following contexts, for example, were raised in the sources. The mass mobilization and the insufficient training of soldiers and officers reduced cohesion and increased friction within units. This, in turn, encouraged crimes like desertion or violence against superiors. Or the inability of logistics to supply soldiers properly, a constant problem in the army during the whole war, led to a dramatic increase in looting, theft, or embezzlement. Therefore, the crime rate does indicate structural deficits in the Japanese way of waging the Asia-Pacific War. And at the same time, The assaults on the civilian population constituted for them an everyday experience of the Japanese occupiers' disregard for the norms of warfare. My second and last point, from the very beginning of the war, deviant behavior was addressed as a severe problem, both by the military justice bureaucracy and by the central authority in Tokyo. This referred equally to crimes within the military, as well as to crimes against the civilian population in the occupied territories. While all crimes were considered to be a threat to discipline and thus the functioning of the army, the latter was also seen as something that endangered both Japan's war aims as well as the honor and the reputation of the imperial military. Consequently, Tokyo took after 1938 a variety of countermeasures to fight the high crime rate. These included an increased staffing of the overtaxed campaign and the judicial bureaucracy, a tightening of the army penal code, a stronger control of commanders and potential criminals, repeated and unsuccessful attempts to eradicate the practice of informal punishments, as well as the offering of recreational spaces for soldiers, including the notorious comfort stations, to tackle rape. And yet, despite the awareness of the dangers posed by crimes, the countermeasures taken proved insufficient. In my perspective, this is evidence that the structural reasons and latitude for crime under the conditions of total warfare proved to be too deeply rooted to be eradicated. Furthermore, it reveals that Tokyo's steering competence vis-à-vis a commander-centered military justice system was rather limited. It remained not only an individual decision to commit a crime, but also an individual decision of persons on the ground how to deal with it. Thank you for listening, and I'm looking forward to your questions and comments.
Thanks for your presentation. Perfect on time. We will continue with the second presentation by Professor Matthias Zachmann, and he will talk about the standardizing military violence, the role of judge advocates in the Japanese Imperial Army during the Second World War. And he will include the Imperial Japanese Navy as well, what makes it even more interesting to me as a naval officer. Matthias Zachmann is since 2016 Professor of History and Culture of Modern Japan at the Freie Universität Berlin. Zachmann's research focuses on the intellectual and cultural history of modern Japan within the context of East Asian international relations, as well as law and legal history in East Asia. He is particularly interested in the transfer of political ideas and cultural institutions, their strategic reinterpretation of discourses on modernization and national agency, and the practical consequences this has for the foreign relation of Japan, particularly in East Asia. His recent research project is Law Without Mercy, Japanese court-martial and military courts during the Asia-Pacific War 1937 to 1945. This presentation will describe the complex role of the military justice fulfilled in the Japanese Imperial Army and Navy during the war, particularly concentrating on the many intrinsic and outside factors that influenced their practice. He draws a broader picture starting in the Sino-Japanese War and will concentrate on a field diary of the successive head of these legal departments. Professor Zachmann, the floor is yours.
Warring parties, as we have heard in the first panel of this conference, routinely justify their actions to each other, the world and their domestic audiences by professions to civilization, self-preservation, or any other ideal. And yet, the realities of the war often stand in stark contrast to these professions of lofty ideals, much to the detriment of the civilian population. No more is this discrepancy starker than in the case of Japan's conduct during the Second World War. We have heard it already as the only non-Western imperial power, if we discount the Ottoman Empire for a moment. Japan traditionally was very intent on demonstrating that it played by the book of civilization and heeded the laws of war. And we can see that in the Russo-Japanese War and in other wars as well. And also during the Second World War, lofty professions by the Japanese government of ideals such as the Greater East Asia Co-Prosperity Sphere abound. Similarly, the Japanese government and military publicly committed itself to the traditional laws of war. And yet, Japan's war conduct is notorious for its many massacres, the first and arguably still the most contentious of this being Nanjing, the Nanjing massacres in the first months of the war with China between end of 1937 and early 1938. Our contention is that military law and particularly military justice played a significant yet little understood role in Japan's war conduct. This it did not necessarily do as an instrument to contain illicit violence, but also by standardizing permissible violence under the guidance of military necessity. In this process, military lawyers and especially the judge advocates assumed a key role. After we have just now heard about the macro perspective on this from Tino Schölz, I now want to illustrate the connection between law violence and military necessity from a micro perspective by particularly looking at the massacre of Nanjing and the road leading towards it. But I must caution, of course, that this is just a very momentary glimpse of the development, and we have to, of course, see it in the context of the numbers that Tino Schölz has provided us already with. The campaign against the nationalist forces in Nanjing in the autumn and winter of 1937 was essentially carried out by two armies, the 10th Army and the Shanghai Expeditionary Army. Both had so-called legal departments. These conducted investigations and brought charges against delinquent soldiers before a court-martial. Fortunately, a wealth of sources have survived from the 10th Army. Both the field diary of the legal department and the judgments of the court-martial are extant. In addition, we have the private field diary of the head of the legal department, the military lawyer Ogawa Sekijiro. All sources combined provide a fascinating insight into the working life of military lawyers at the beginning of the Sino-Japanese War. Ogawa went with the 10th Army to Nanjing and was an eyewitness to what happened there. In this respect, his diary is also an important document for the Nanjing massacre. But curiously enough, this source is still relatively unknown and has never been studied in full. Yet this source provides a fascinating insight. Ogawa Sekijiro was a seasoned military lawyer. He had participated in many high-profile trials. And this 1937 tour probably was only meant as a final lap of honor before he was to go into well-deserved retirement. So from the beginning, it was thought that the Chinese campaign would take only a few months, and then China would fold, and then they could all go back do their victory lap. But this didn't happen, as we know. But as so many soldiers, Ogawa kept a diary for personal reasons, and this is what you see on the screen. He says that in the first days he couldn't take a camera with him. That apparently was forbidden, and so he took as many soldiers. He conducted a diary for personal reasons to note down his observations. To clarify the role and the position of judge advocates, as Ogawa was one in general. We must bear in mind that the role of the military lawyers in the Japanese army was a relatively recent and marginal one. Proper military lawyers or judge advocates, to use the widely known American parallel, did not exist in the Japanese army until 1922. Before that, there were lawyers, but they did not officially participate in the process. They only worked as advisors, and only from 1922 they conducted investigations, brought cases to trials, and acted in a trial as a prosecutor or one of three judges. But as can be seen from these figures, there were also very few of these lawyers, only 75 at the beginning of the Sino-Japanese War, and this number did not change significantly over the next few years. Even only after the attack on Pearl Harbor did this change substantially. But still, the numbers were very low. So at the beginning of the Sino-Japanese War, this meant for the 10th Army that they had a very small legal department and were very small and stretched thin. It comprised exactly 3 judge advocates and 3 legal assistants. This meant that 6 people were responsible for investigating and disciplining an army of 200,000 men. It is obvious that not all crimes and offenses could be punished in this situation. But this quote from Ogawa's diary shows that a legal department that was too active was not at all welcome either. Ogawa here complains that if they handled too few cases, they were despised as being lazy and useless. But if they were busy and handled many cases, they were criticized for being overzealous. In any case, they were caught between a rock and a hard place. Nevertheless, Ogawa proudly notes in his diary that he and his staff were extremely busy beyond all expectations. But the reader subsequently learns with astonishment that this meant that between the beginning of the war, or when the legal department started working in October 1937, and the end of 1937, that is in 3 months, the 10th Army Legal Department had handled only and exactly 26 cases. Of these, almost half of the investigations were dropped. That is, the case never went even to court. Only 14 of these cases resulted in a trial and subsequent verdict. It is even more interesting, however, when one looks at the ratio of dismissals and indictments broken down by the kind of offenses. Almost all cases in Group 1 were dismissed, that is, in cases involving property crimes such as theft, plunder, and arson. The reason for this was that the 10th Army, as Tino has already explained, was logistically not equipped for the long march to Nanjing, and the soldiers almost routinely supplied themselves by plunder. In addition, houses along the way were systematically burnt down so as not to provide shelter for enemy soldiers. The cases with the second most frequent number of dismissals were those of sexual violence. 6 out of 9 were not even brought to court. We'll come to the reasons for this in a moment. Next come the murder cases. Of 5 murder cases against Chinese civilians, 3 were punished, but 2 were also dismissed. Again, we will come to this in a moment. But most tellingly, the cases with the lowest number of dismissals, and those who were prosecuted most actively, therefore, were those involving violence within the army, namely threatening a superior, desertion, and destruction of military property. Although this is a very limited statistic that we have seen to see in the context of the larger numbers, it nonetheless very well illustrates the typical hierarchy of protected goods and the overriding ratio that guided military justice. First and foremost, the military justice system sought to protect the fighting power of the army and its strategic goals. That is, the command hierarchy, its fighting power as such, and its material. Conversely, the least protected goods in this hierarchy were life, limb, and property of civilians. And the overriding rationale for this hierarchy was the so-called and often heard military necessity, of which we already heard a lot in this conference. But all other considerations were placed secondary to this military necessity. And we'll see how this plays out. Because it is also interesting what was considered particularly necessary from a military point of view and what was not. And this is shown by this we can see by looking at individual cases. For example, the case of Soldier Ko, the names are always abbreviated, who drunkenly slapped a superior in the face. For this, he received 18 months hard labor. But it was not only the assault on the superior that deserved such harsh punishment. It was also the fact that this act of revolt happened in Nanjing during the street fighting that is in full view of the enemy, which added to the severity of the punishment because it blemished the honor of the army. So military honor was therefore of premium importance, the protection of which was considered a very important military necessity. Rank and status were also an important part of it. This can be seen in the second case, in which Soldier Ori, not drunk this time, but annoyed by the behavior of his superior, his arrogant superior, fired a shot into the air. For this, he received a whopping 5 years hard labor, just by shooting in the air. Reading between the lines in Ogawa's diary, however, one can see that one factor that exacerbated the severity of the punishment was Ori's class affiliation. He was not only a common soldier, but also, as Ogawa writes, a vulgar, loud-mouthed fellow who terrorized the entire unit with his dissolute behavior. Status and class, therefore, could decide over being punished or not being punished. So the only case in this category that was not pursued was against a major. No one apparently wanted to rock this boat and blemish the honor of the major. In another case, a rape case, that the high-ranking defendant was left with a gun so that he could commit suicide. Military necessity also dictated the handling of crimes against the civilian population. The 10th Army's legal department prosecuted rape only in the most serious cases, namely when the women were also killed. All other minor cases were not prosecuted. But the number of rapes rose so drastically in and around Nanjing that Ogawa finally noted in his diary at the end of December 1937 that he might have to reconsider this policy. Even the chief of the field police, Kamisago, complained to Ogawa that the legal department hardly brought any charges, even though the field police were arresting countless soldiers. This did not make any sense, and in any case would also have a negative impact on future pacification efforts against the civilian population. But Ogawa tried to dismiss the criticism. He referred to the so-called comfort stations that would soon be set up. These would prevent, he argued, attacks against civilian women in the future. We know, of course, that this was patently untrue. Moreover, the conversation and the handling of sexual crimes in general show that the military authorities were hardly concerned with the welfare of the victims as such. It was solely about the honor of the army and the enforcement of strategic goals. This disregard is, of course, also evident in the so-called comfort stations, which were themselves a form of institutionalized rape and were co-organized by the field police. Murder cases showed a clear division along gender lines. All cases brought to trial were murders of women. Murders of Chinese men, on the other hand, were not prosecuted, and the investigation was dropped regularly. The military rationale for this distinction was, which is also evident throughout Ogawa's diary, was that Chinese men were categorically regarded as potential enemy combatants. In addition, racism also played a role. And this is particularly apparent in this case. The accused Lieutenant Yoshi, together with his unit, arrested 26 Chinese who had been suspected of stealing public property and unrestful behavior. On the way to the nearest police station, Yoshi then had all 26 detainees shot. The investigation records state bluntly that this was done because there was a concern that the detainees would escape. But Ogawa reports in his diary that the leader, Lieutenant Yoshi, in the interview stated that he had acted out of a particular desire to kill. His unit had not fought at the front, and they had killed the Chinese out of a certain curiosity and because they did not respect Chinese as humans. Nevertheless, the case was struck down, so it never made to the court. So it can be seen that the low level of protection of civilians was motivated by a variety of factors. Mistrust of the population as a potential enemy was one, as well as racial and ethnocentric prejudices. This may also have been the reason why international law was never applied in cases involving Chinese. Only when Western foreigners or Western foreign assets were involved did international law come into play. Another reason may have been that the commander of the 10th Army, Yanagawa, so Ogawa's superior, apparently assumed that the struggle with China was an absolute, that is, a total war. This absoluteness blurred lines between civilian and military concerns, and so it was only natural that the war produced so many casualties. Since the commander officially was the final arbiter in courts-martial decisions, it is no wonder that this view filtered down into the decisions, or at least that he did not oppose them. I mean, practically speaking, Ogawa proposed verdicts or decisions, and the commander often said just said yes, and then So Ogawa was probably the most influential in this process. But still, he acted in a way in accordance with his superiors' views of the war. But probably the strongest influence of Ogawa's decisions was the war itself and the sheer numbing pervasiveness of violence around him. In this sense, Ogawa's diary also tells the story of a moderately civil person descending into hell, at the bottom of which is Nanjing, and at the end of which comes out a rather callous and completely desensitized observer. The erosion of Ogawa's sensibilities visibly progresses day after day. At the beginning, he's still shocked by the wanton devastation around him that is caused by looting and arson, and does not believe that Japanese soldiers could behave in such a way. He also pities the population of being of a defeated nation, but this is often very formulaic. But the more he approaches Nanjing and the more death and devastation he sees around him, he assumes the persona of an hard-boiled veteran who cannot be shocked by anything anymore. This reaches its height when entering Nanjing, and he observes the hellish scenes that unfold there. So he notes, for example, seeing these things, I do not feel anything in particular. The Japanese soldiers too are almost unaffected and look on without emotion, as if these corpses were just things on the wayside. This spectacle is also something which one can experience only in war. Ogawa's most quite obvious identification even goes beyond the war. When he is asked to give a written affidavit for the International Military Tribunal for the Far East, the Tokyo trial, he assures the prosecutor that he saw only 6 or 7 corpses of Chinese soldiers in Nanjing and no other. But this is patently a lie, because in his diary he describes the heaps of smoldering corpses in detail. So he perjured himself after the war as well. In this state of dissociation, being in Nanjing, all becomes a spectacle. He climbs the rooftop of a large building in Nanjing and, like Nero, observes the burning city with the words, "Only in war can one see such a spectacle. Getting the opportunity to witness the reality of war with one's own eyes is truly a once-in-a-thousand-years chance." And this all eventually leads him to the nihilistic conclusion: war is the definition of doing as one pleases. In any case, doing anything and everything as one pleases is a spectacle one can only observe in war. But it's quite obvious. Ogawa makes this statement with amazement, but also a certain kind of admiration. But it's quite clear that him being a judge advocate, this comes tantamount as declaring capitulation for any form of jurisdiction. So this brings us to the end and conclusion of our investigation into the role of military justice in Nanjing. We can see that military necessity was the overruling principle, which was above everything and had an erosive effect on the judge advocate's role. He standardized permissible violence almost exclusively to meet the requirement of his commander and the war situation. And in the case of the legal practice of the 10th Army before Nanjing, in Nanjing in 1937, this meant that justice could be merciless when military necessity required, especially the protection of discipline and honor. But on the other hand, the military justice system could also be appallingly moderate or even inactive toward delinquent soldiers when rank, honor, racial or sexual prejudice dictated. So in any case, however, this selective practice had dire consequences for the civilian population and wreaked havoc on their lives. Thank you very much.
Thanks a lot, Professor Zachmann. Now we come to the third presentation by Dr. Kelly Maddox. It's about the limits of military necessity, unlawful trials and summary executions in the Andaman and Nicobar Islands during the Japanese occupation in 1942 until 1945. Kelly Maddox is a researcher at the Seminar of East Asian Studies at the Freie Universität Berlin, and she works currently on the project Law Without Mercy, Japanese Court-Martial and Military Courts During the Asia-Pacific War 1937-45. She will focus on the post-war tribunals on the issues of unlawful trials and summary executions and the tensions between military necessity and international law in the eyes of military justice. Kelly Maddox, now the floor is yours.
good afternoon. So my paper today will take a different approach from that of my colleagues. Rather than presenting an overview of the Japanese military justice system as imposed over civilians in occupied territories, I will be shifting the focus to the evaluation of this system during post-war war crimes tribunals. Although we must be cautious about using such materials given the overt agendas at play in these trials, in view of the relative scarcity of surviving sources about military practices in respect to civilians under Japanese occupation, they can sometimes provide useful insights. They can, for instance, give us some hints as to how military necessity may have factored into or may have been used to justify commanders' decisions to employ force or to use more radical, illegitimate acts. Moreover, the post-war tribunals were foundational in setting more plainly and decisively the parameters of acceptable conduct of occupying powers towards civilians and therefore are vital to our historical understanding, especially of the limits of military necessity. So military necessity was used in a number of the post-Second World War tribunals to defend against, or at the very least to mitigate, charges of violating the laws of war. It was particularly prevalent as a defense in cases which involved what we might term the denial of justice. So these were things like executions that took place without trial, or executions or punishment that might have taken place after unfair trials. The adjudication of these denial of justice crimes presented some challenges. Members of war crimes courts had to determine, first of all, whether certain uses of legislative or judicial power by belligerents were in fact prohibited by the laws of war, and whether violation of these prohibitions actually constituted a war crime. And as demonstrated in a selection of cases which were included in Volume 5 of the United Nations Law Reports of Trials of War Criminals, cases which concerned the administration of military justice over civilians in occupied territory proved particularly difficult to prosecute, often resulting in lighter, commuted, or even unconfirmed sentences. Much of the complexity found in addressing these crimes stem from the ambiguities as well as the omissions and oversights within international law at this time regarding the rights and the duties of occupiers in relation to civilians. So aside from these articles that I have here on the slide, the Hague Conventions contain no other enumerated obligations or restrictions on occupiers in regard to the administration of law and justice in occupied territories. In fact, the right of belligerents to exercise legislative and judicial powers over civilians was widely understood at this time to be rooted in the doctrine of necessity. And you can see here a couple of extracts from Allied military manuals around this time demonstrating this. So while it was also understood that these powers were not limitless, codified international law offered little in the way of clarifying what these limits were and how necessity should be interpreted in this context. It is unsurprising then that efforts to prosecute and to defend against charges of the misuse or abuse of judicial authority in the aftermath of the Second World War would centre on the issue of military necessity and be complicated by a lack of clarity about, as well as conflicting interpretations of its limits. In my paper today, I hope to highlight some of these issues by examining two cases tried by the British, which involved the denial of justice to civilians by Japanese forces during the occupation of the Andaman and Nicobar Islands between 1942 and 1945. This is quite new research, and I hope that you'll forgive that it's still very much a work in progress. But I nevertheless hope that some of my preliminary observations will prove interesting nonetheless. Before I begin with the cases, I'd just like to give a very brief introduction to the occupation of the Andaman and Nicobar Islands, focusing particularly on the specific situation regarding the administration of military justice in what was a relatively isolated area. The Andaman and Nicobar Islands, a former British colony, had not been part of the Japanese military leadership's initial plans for the so-called Advance South in 1941. In fact, they were viewed as having practically no material value. Upon completion of successful operations in the Malay area in February 1942, however, the islands began to hold greater significance, strategic significance as a potential defense base. An invasion called Operation D was therefore launched on the 23rd of March 1942, and the occupation of the islands by a combined army and navy force was completed, without resistance on the part of the British by the 13th of June. Thereafter, the islands were placed under the Navy's area of administrative responsibility. Now, as in all occupied areas, the maintenance of public order was considered to be of paramount importance. Martial law was declared, and civilians were warned from the outset that severe punishments would befall anyone who violated it. As offences which impacted the military and its activities, violations of martial law were to be adjudicated in military courts exclusively. Since there was no Navy legal department or regular military court in the islands, legal officers had to travel from Navy headquarters in Singapore in order to try offenders. This system worked at first, but became untenable towards the end of the war as Allied bombardment and blockades in the region devastated transportation routes, making it logistically difficult, if not impossible, for legal officers to be sent to the islands. Commanders then were left to adjudicate violations of martial law in this area as they saw fit, and without the support of or expertise of a dedicated legal department. During the last 2 months of war, hundreds of civilians in the islands were executed, ostensibly for serious crimes. Some were killed summarily, having apparently been caught red-handed, while others were executed after military trials established ad hoc in the field. Such actions were defended as those of military necessity, unavoidable in dire and deteriorating wartime conditions, and essential for the protection of Japanese forces. They were viewed by the British, however, as unlawful trials and illegal summary executions, representing a serious breach of international law. So the discussion which follows will now explore the ways in which these charges were handled during 2 important cases. The first is the trial of Hara Tezo and 5 others, held at Singapore towards the end of February 1946. The accused in this trial were all charged with the killing of 9 Burmese civilians in the Andaman Islands during early August 1945. The facts of the case, as summarized by the prosecution, were that in early August, 9 Burmese civilians were captured while attempting to escape Andaman Island in stolen boats by Lieutenant Harada Kunichi at Stewart Sound. So this was a small island about 150 kilometers north of the capital, Port Blair. Upon concluding an investigation, Harada made a report and requested orders from Vice Admiral Hara Tezo, who was the Commander-in-Chief of Navy forces in the islands. On the 13th of August, these civilians were illegally executed by means of stabbing and beheading with bayonets and swords. The defense contended, however, that these had been lawful executions, carried out in accordance with a sentence pronounced in an albeit ad hoc military court, which had been convened by Hara at Navy headquarters in Port Blair on the 6th of August. Regrettably, but unavoidably in light of the wartime situation, these 9 civilians could not be present at the trial. Defense arguments made in support of this contention included highlighting the critical situation informing Hara's decision and the necessity of holding the trial in this manner, which had, the defense lawyers argued, been carried out in compliance with Japanese regulations. The key points of this defense can be briefly summarized as follows: that attempted escape and theft of military supplies at such a critical juncture in the war were serious offences. They were subject to severe punishment and required a trial by military court, but there was no standing military court in the islands, and Allied bombardment and blockades had meant that a legal officer could not be sent to convene one. Hara had the authority to do so and initially planned to have the Burmese brought to Port Blair for this purpose. However, dangerous weather conditions, due to it also being monsoon season, had made it unsafe to do so. Since there were no resources or manpower to keep these people in custody at Stewart Sound, and regulations did not entitle Hara to delegate judicial power to junior officers, it was decided to try these civilians in their absence based on documentary evidence produced during the investigation. This was not fundamentally in contravention of Japanese regulations or procedure regarding military trials for civilians, because according to the Navy Penal Code and the martial law regulations of the 10th Area Fleet, provisions for defense did not apply in military courts for civilians anyway. So in summation, Hara had done his best to provide a fair trial, and he believed his actions to be lawful given the adverse and urgent circumstances in the islands. Moreover, not only were the summary procedures adopted lawful under Japanese regulations, but they were also allowed under international law, given, and I quote, the peculiar characteristics of organizing trials in occupied areas. Although the defense lawyers did not elaborate further on this point, They were successful in persuading the court of the legality of the trial under Japanese law, and those involved in the trial itself were found not guilty. However, those who had carried out the execution were sentenced to death for doing so in an unnecessarily cruel manner. They'd used swords and bayonets rather than firing squad. So this was much to the surprise of the confirming authority, who had tended to agree with the prosecutor's assertion that no such trial had actually taken place, and that in any case, the situation had not been so bad that civilians could not have been brought to Port Blair, or at the very least held in custody pending trial. But because Hara, Shimazaki, and Toyoshima were already on trial for another incident in the Andaman Islands, the sentences were nevertheless confirmed. So the second case that I'd like to introduce today is the trial of Itsuki Toshio and 15 others, which was also held in Singapore in March 1946. All of the accused in this trial were charged with the torture and ill treatment of civilian residents of Car Nicobar in July and August 1945. 3 of them, and you can see the names here on the slide, were also charged with the unjust trial and judgment of those residents, whereupon a total of 83 people were condemned to death and executed. The facts of the case, as summarized by the prosecution, were that Allied bombardment of Car Nicobar, which was the northernmost of the Nicobar Islands, had begun in earnest in March 1944 and intensified throughout 1945. Due to the surprising accuracy and the success of these bombing campaigns, as well as the alleged visibility of signal lights from the island, Japanese forces had become suspicious of the residents. On the 5th of July 1945, the day of the final air raid, a man named Taruka was arrested for stealing rice. During the investigation, an oil lamp was discovered hidden near his home, and under torture, Taruka had revealed the existence of a spy organization, seemingly confirming these suspicions. An investigation was launched by the Navy under Captain Ueda Mitsuharu, who was supported by army personnel that had been sent to reinforce the island in 1944. Initially, 55 residents were arrested and interrogated. Beatings and other forms of torture were used to extract confessions. However, these investigations weren't believed to be proceeding fast enough, and in mid-July, Major General Itsuki Toshio, who was commander of the Army's 36th Independent Mixed Brigade, took over. With more personnel at hand, further arrests were made and interrogations continued until late July. By the time the investigations were concluded, 4 residents had died in custody. A further 4 were released, and the rest were executed in 3 groups by firing squad on the 29th of July, the 6th of August, and the 13th of August 1945. To account for this, the Japanese had submitted copies of the court proceedings as an account of a trial of these so-called spies prior to execution. So the main defense arguments in this case were quite similar to those presented in the Hara case. They involved underscoring the necessity of resolving the issue of espionage quickly, pointing out the unfavorable war situation, and emphasizing the legality of trials which had complied with Japanese army regulations. So the key points may be summarized as follows. In 1945, Car Nicobar was the most strategically important of the islands because Japanese forces had successfully constructed 2 airfields. Japanese forces were therefore expecting an imminent Allied attack and were busy with defensive preparations. There had been clear evidence of an underground spy ring in the islands, and the existence of such was dangerous. Therefore, it was of the utmost urgency that the truth of this be uncovered and spies be liquidated. To expedite this, the use of force in the form of beatings had been permitted. In the interest of concluding the spy investigations, in view of the lack of resources to maintain custody and the impossibility of getting a Navy legal officer to the island, Itsuki decided to convene a military court. He was authorized to do so according to Southern Army martial law trial regulations, which had, incidentally, been revised in May 1945 to allow for more streamlined and convenient procedures at this point in the war. The trials had been short, not by design, but because all defendants had admitted their guilt and confirmed the charges against them, requiring less time to complete proceedings. Procedure had been carried out in accordance with Japanese martial law regulations, and the defendants had been punished for their acts as spies as permitted by international law. In summation, this was the most fair and just trial which could be held under deteriorating wartime conditions. Now, the prosecutor's counter-arguments in regards to these trials are quite interesting. He had asserted at various points during cross-examination that the trials had been unfair, and contended in his closing address even that, and I quote, "Japanese law is completely irrelevant as an excuse for an unjust trial." The crux of his argument, however, lay more in challenging the fairness of the judgments than it did in pointing out any illegality in respect to the constitution, composition, or procedure of these trials, as was stipulated in Japanese regulations. Using the court proceedings, which had been handed over by the accused, and which contained just a narrative summary of events, followed by personal details of each of the defendants, the prosecutor observed that the judgments made in court had been based solely on confessions obtained, as the accused had admitted, through the use of force. No material or documentary evidence of an espionage ring had been presented at these military courts. Moreover, in spending what amounted to just 2 to 3 minutes with each defendant, the judges had made no real effort to ascertain the truth of the confessions. The death sentences, therefore, had been unreasonable in light of this evidence, and the judges could be held responsible for unjust executions. Now, with the existence of court proceedings in this case, and the fact that they were the basis of some of the prosecutor's arguments, the prosecutor did not really question whether trials had taken place, as they had done in the Hara case. But as a matter of fact, they hadn't. So according to the post-war recollections of Captain Sumi Toyosaburo, who was one of the accused, the alleged spies had actually been summarily executed, and the court proceedings had been fabricated after the fact, upon realization that international law required that spies be given a trial prior to punishment. It was believed that providing some evidence of judicial proceedings, even if imperfect and ad hoc, might give legitimacy and mitigate to the acts and mitigate the charges. Summary field trials had been used during the Russo-Japanese War, after all, and these had been considered lawful. Ultimately, this tactic failed. The court found, and the confirming authority agreed, that the trials had been a travesty and mockery of justice, and all 3 of the accused that were involved in them were found guilty to varying degrees. So in bringing my paper to a close, I'd just like to make some very preliminary observations based on these cases. Firstly, that the ambiguity regarding the limitations on judicial rights of occupiers in codified international law, and the fact that such rights were tethered to another concept, military necessity, which also held an undefined status within the laws of war at this time, enabled the establishment and the subsequent modification of martial law regulations, which did allow for summary trial procedures and did offer few judicial safeguards for civilians. Secondly, in view of lack of clarity about the limits of military necessity at this time, Japanese commanders could, and if the testimony given during these trials is to be believed, did interpret the concept to mean that certain uses of force and judicial power, especially that which had not been formally prohibited by international law, were permitted under certain circumstances. Of course, the issues raised during these and other post-war tribunals informed and were largely addressed in the Fourth Geneva Convention of 1949. Articles 64 to 78, for instance, provide greater clarification and much more detail regarding penal legislation and the judicial procedures which should be followed by occupying powers. But the right of belligerents to administer law and justice, as defined in Article 64, which I have here on the slide, is still, in my perspective, rooted, albeit more implicitly, in the doctrine of necessity, and as such still requires some kind of subjective assessment of what exactly is essential. And this is important in light of my final observation, that Japanese commanders were making their assessments about the necessity of adopting certain practices or undertaking certain actions in a specific, although mutable, wartime context. In developing our understanding of why commanders might adopt more extreme, more radical methods then, it is quite important to consider the ways in which this unique and fluid context shaped their decisions and their interpretation of necessity. So thank you very much for listening, and I look forward to your comments and questions.